Good morning. I'd like to call this meeting to order. Thank you for joining us during our weekly hybrid MLS breakfast meeting. My name is Yin Burr, and I'm your November program chair. I want to take this opportunity to thank Jolene Chu, the vice chair of MLS committee, for filling in for me last week while I was at NAR meetings. A little bit about me. I've been a member of this association since 1991. I thought it was earlier, but I found out that it was only from 1991, and it's long enough. But I've been in the real estate industry since 1982, working in an appraisal firm, which was the multidisciplined appraisal firm in Los Angeles. So in my spare time, I like to travel and also play golf. But I'm very active in the local, state, and national associations. So sometimes you don't see me here, it's because I'm at one of those meetings. But when I'm not at those meetings, you see me here. So that's enough about me. Let us go to the next item on our program, the most important one. We have our speaker, Paul Cheng, here, and he doesn't want me to read his bio because, as we know, we all know him, right? But I do have an announcement to make about Paul. He was just re-elected as the council member of City of Arcadia in District 4. Congratulations.
Just quick disclaimer, I am on city council in the city of Arcadia. I do not represent any of the council members or the city of Arcadia in the presentation. The perspective today is completely from an attorney standpoint. Obviously, I'm going to weave in some of the things that I know about city life, but that does not mean that you can go to the city of Arcadia and be able to use that. All right, very quickly, you've seen this before. Many of the slides you have seen before, so it shouldn't be very difficult. So in the US, laws are split into criminal and civil. Next slide. And then civil is split into two types. The first type are called torts. The second type are called contracts. So a tort is a non-contract civil claim. And the reason why I share that is because an attorney is going to think that way when you talk to them. So the first thing that they're going to ask themselves is this a criminal case or is this a civil case? In a civil case, they're going to say, is this a contract case or a non-contract case? Within the non-contract case, it's going to be split up into three types: an intentional non-contract case, a negligent non-contract case, or a strict liability non-contract case. So I'm going to explain what they are very quickly. An intentional tort is that you need to have the intention to do it. If you have the intention to do it, you are liable. For example, you're in a bar fight, right? And you're going like this, and somebody sues you for hitting them. But on defense, you prove that you had a stroke. You prove it. And you are doing this because you had a stroke. In that case, the intentional tort of battery, the defendant would win because you don't have the intention to hit somebody. What is negligence? Negligence is where society has set a standard and you fall below that standard. I'll give you an example. Let's just say that you're in a car accident. You're in the back and somebody's in the front and they stop at a red light. Not fraudulently, but they stop. You hit them from the back. You're going to be liable, the car in the back, right? Because society has said that when you're driving, the car in the back has to be careful when the car in the front stops at a red light. That's negligence. What is strict liability? If it happens, you lose. If it happens, you lose. What does that mean? For those of you that own dogs, if your dog bites somebody, 99% of the time, you're going to lose. That's strict liability. So the law says if it happens, you lose. Why do I share this with you? I share this with you because this is the first year of law school. And so attorneys are always thinking in this capacity when they meet with you. Now, in terms of contracts, that's where real estate falls in, right? So real estate falls in the contract realm. Yes, there are negligence actions regarding real estate, but most attorneys are thinking in their head that this is a contract issue. Okay, next slide. There are many lawsuits in the United States. There are many, 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 many. We have more lawsuits in California than we do in the United States. We have more lawsuits in California than all the states' federal cases combined. So we can go to the next slide. Okay. The first issue I just want you to know are those that do not claim to read English. And this is very important because that is a common defense in real estate transactions. I did not read English, but I want you to know, though, that in this capacity, it is very, very difficult as a defense to be able to use it, because if you look at the law, most people can be able to consent if they do it freely. And so that's very important, is that California law says that if you freely do something, you're able to consent. And so not being able to read English is not typically a defense that can be used. It's used often for purposes to say that they were defrauded, but as a general rule, you cannot use that to be able to say that I don't think that I need to comply with my contract. And why is that very important? It's important because today what I'm doing is very quickly going through the issues that I see in real estate transactional lawsuits. Next slide. No attorney-client privilege. This is very important. So a lot of times, for some reason, people don't feel that they could be honest with an attorney for whatever reason, but they tell everything to their real estate broker. And so this is actually quite serious, because we're going to talk about the fact that you may need to disclose in your real estate transactions what they tell you. And if you don't, you could actually be personally liable. And so this is important. Another issue about stop giving legal advice is, I understand, because you're dealing with somebody's most precious transaction, right? Which is their home. And so I do understand that people are coming to you frequently for legal advice. I would recommend that you text them back. You could say, this is my opinion, but I'm not an attorney. You should go find an attorney. And the reason why that's very important is the cases that I see that, it actually helps out a lot, because typically what ends up happening is that most people that are unhappy about their transaction really do seek to bring in the agents that were involved because you have insurance. Okay, next slide. Oral promises. I just want you to know that all real estate transactions I've seen, so I just say most, but most real estate transactions that I've seen have what's called an integration clause. And what an integration clause means is that there's going to be no oral promises that are allowed in the agreement. However, you still need to be careful about the integration clause, because it always says that the last agreement controls. So the problem is, you're signing documents along the way. Each one has an integration clause. And so I want you to know that what an integration clause, it's actually two things that are very important. One, oral promises do not exist. Two, the last contract controls. So if you had a promise in an earlier contract and the last contract does not have it for whatever reason, I just want you to know that the last contract controls. And so I've had agents get in trouble because they were like, oh my God, the promise was previously in there, but it's no longer in there now. And they get sued because your client felt that that was a promise that should be included. So I just want you to know, be careful on real estate contracts. They always have a clause that sounds like this. This agreement, together with the other loan documents, this is just an example. I pulled it from a loan document because it's written well. Represent the final agreement among agents, lenders, and borrowers. It may not be contradicted by prior, contemporaneous, or subsequent oral agreements of the parties. There are no unwritten oral agreements among agent, lenders, and borrowers. So you're always going to see this type of language in every single contract. This is actually probably one of the biggest issues that we have, is what contract actually controls. And in real estate transactions, unfortunately or fortunately, it's always the last agreement that controls, because of the fact that everybody signs off on it. So you're always going to have some language like this. All right. So again, integration, one, it eliminates all oral agreements, which is a problem, because if you're representing a buyer and the buyer thinks that they're going to do X, Y, Z, it's not in there. And two is that the last agreement controls. Okay, next slide. Failing to disclose defects on property. I just want you to know I think over the years, we've talked over and over again to realize that even when there's as is, you still have to disclose, right? So in California, it's funny because everybody thinks as is as is, but I think someone just whispered, which is very intelligent. You should really just think about it as there is no as is in California. So you put it in, right? You put it in, but if you know of a defect, just put it in anyway, right? Because if you're actually selling a property and it's a very hot commodity, you could put in there that there was an elephant in there before and they'll still buy it, right? So the more, if you really are in that seller's mentality and it's a very good purchase, I would just disclose everything that you like, everything that you can be able to do, even more, right? Does the neighbor smell, right? Do they have a camera that's like some crazy neighbor that's pointing their camera at you? You period, just put it in. Nobody's going to care, but they do care after. So I'm noticing that there are three types of lawsuits after COVID. One are divorces, two are shareholder disputes, and three are real estate transactions because they have the longest statute of limitations. So fraud, you have up to 3 years, and breach of contract, you have up to 4 years. So this is actually, pretty intense. So you have to be very careful because a lot of the transactions that occurred pre-2025 are now being looked at by attorneys. Because you have to realize when there's insurance, everybody wants a piece of the pie, right? Okay, next slide. Escrow instructions. So you're going to have a lot of people from the East Coast. East Coast, you have to remember attorney-led transactions, but on the West Coast, we use what are called escrows. And escrows many times are dealing with the transactions, right? But I want you to know that what I've seen is that the purchase and sale agreement or some random document actually contradicts the escrow instructions. And I understand the escrow instructions are supposed to be more just the financial terms and things, but I do see contradictions between random agreements, purchases sale agreement, as well as the escrow instructions. And ultimately, what ends up happening is we have to look at the last agreement because we talked about the integration clause. The last agreement controls. So I just wanted to let everybody know that as you're working with escrow, you have to be very careful. Okay, next slide. See, we're already halfway done. I mean, we're already halfway done with the time, and I'm like 1/3 of the way done. So it's actually not good. So title insurance very quickly. Oh, okay. Go back one. Title insurance very quickly. There are two main types. So I'm just going to tell you that America is bigger than California. America is bigger than California, right? And so therefore, always get ALTA. That's my recommendation. So you're going to be approached with two different title insurance that you don't quite understand, right? One is going to be cheaper than another. However, America is bigger than California. So my recommendation would be pick ALTA. There's going to be less exclusions. It's going to cover more. Why is that important? So the next slide talks about exclusions because exclusions are a big part of any type of insurance. Every insurance, for example, workers' compensation, it sounds the same. You go here buy work comp, you go here to buy work comp. This is $100 a month. This is $180 a month, right? And so everything is just based on a name, but so everything just sounds like, oh, title insurance, everything is title insurance. Well, I would say that typically when you buy any type of insurance, you're not worried about what you buy, you're worried about what's excluded. And when things are excluded from a policy and most people don't read about it, it becomes really bad when there's a lawsuit because that's where the exclusions come in. Notary powers, I've seen a lot of problems with notaries. Notaries are not attorneys. Notaries are not from the court. And so I've noticed some real estate agents use notaries as kind of like, oh, here's the hand of the court because they have a seal. That's really bad move, right? It's going to be very easy and it's going to get the real estate broker or agent in trouble very easily when you act like they're an arm of the judge, right? So in other countries and many Asian countries, a notary has a very high standard, right? And so because of that, when someone comes with notary power in the US, there's definitely a lot of like, wow, this is the arm of the judge. But everybody knows in California, it's really just to identify who it is. So what a lot of agents have done is use the notary mindset of the foreigner to be able to say that what you're doing is so much more legal or so much more powerful. So just be careful. Elder abuse. If you are dealing with an elder, this is very important. If you're dealing with somebody over 65 and they don't quite understand what's going on, after the transaction is done, they will sue you and they will win. Because if you're, so there's actually a lot of real estate agents, they specialize in people who just lost a family member and the person is over 65, right? There's nothing wrong with that. Everybody specializes in their own way. But the thing is that if you're dealing with an elder over 65, you actually have to treat them reasonably. Very vague concept. It's a big hole that you can drive a truck through. Because what ends up happening is that the elder is going to say, wait a minute, I didn't know what I was signing. Before we saw that, oh, it's a very hard defense. I mean, that's a very hard thing to prove, not for elder abuse. So you got to like 10, 15 times make sure. I would even recommend that you record conversations with them with their permission so that you can actually have documented proof that they know what they're signing. If you are dealing with an elder that is truly an elder, you could tell that they're not all there. I really want to warn you that there are a lot of good cases on plaintiff side where they take on elder abuse cases after the elder says, hey, what happened? Because typically an elder will act and then the kids will come in and say, Mom, why'd you do that? Right? And the elder will be like, well, I don't know. I just met this agent. The agent talked to me and they're like, that is like $500,000 cheaper than what you could have sold it for. Right. And then the child takes the elder to an attorney. And then obviously the attorney says, yeah, this is pretty crazy. Right. It's $500,000 cheaper. Right. If it's under 65, if a person is, if the elder abuse statute doesn't control, as long as you're just, it's a regular transaction. But once an elder is involved, then you have to be very careful of elder abuse. Okay. Because they could actually overturn transactions too. So you could have a transaction that's sold and, eventually it could retroactively go back and overturn everything. I actually am in an elder abuse case right now, right? Where the person is 70, 80 years old and there was a property that was sold and he got zero, right? And the question is, how did that happen? How did that work? Right? And so it does happen. It does happen more than you think. My case is obviously a more obvious case, but if you're selling for $500,000 less, the question is, does the elder actually know what's going on? Right? Because basically they're going to depend on your expertise to make their decisions. When you go to them and you say that's the market, you better mean that that's the market. Right? Because that's what everybody says, right? I think the biggest value add of any real estate agent is to know where the market is at, right? I don't know, right? So I have a real estate agent. They come to me, they say, yeah, you know what? It's $800,000. Well, how do you know that? Well, because I did comparables and I looked at it. I don't sit there and look at their comparables. I just depend on the agent, right? That's really the biggest value add, in my opinion, right? So I don't have to guess and speculate. So if you say that to an elder, you really better mean it. Okay, next. Fault of agent. What do I mean by that? This is a disclosure one. This is a disclosure one. Yeah, you just have to disclose. Next slide. Letter of intent. I've seen this more and more. A letter of intent. So this is what I want to say. A letter of intent has many different forms. So we have to be very careful. If your letter of intent does not say that this is non-binding, it's completely arguable that it is a contract. Just because it says the word letter of intent, that means nothing, right? Let's just say that there was an agreement that say bubblegum contract, but everything underneath is not related to bubblegum, right? It's related to a purchase and sale agreement. You wouldn't even care what it said on the top. Do you guys agree with that? Right. So I say that because I see so many letter of intents that do not say that it is a non-binding. It's non-binding. And people are suing on that. So be very careful about these letter of intents. There's also letter of intents that may become binding if there is a further agreement. So my recommendation to you is to look up letter of intent and look up the different types, because in California, we use letter of intents a lot. So some are binding, some are non-binding, some terms are binding if there's an agreement, but not binding if there's no further agreement. So just be very careful. This is starting to become an area attorneys really love. Just common contract provisions and issues that I see problems with. Attorney fees are in there, which is good and bad. If you're in a transaction and you think that there's going to be litigation on it, remove your attorney fees clause. Because a breach of contract without attorney fees, you don't get attorney fees. There are many attorneys that are able to sustain lawsuits because they can tell the client, if you win, then you get your attorney fees back. Well, 97% of cases settle, so you don't get your attorney fees back, right? But what I'm trying to tell you is that the attorney fees provision, if you feel you are exposed for whatever reason, then why not eliminate the attorney fees provision? Second one is venue. I've seen issues of venue foreign contracts where they don't know where they are going to litigate the issue, right? You have a person from Shanghai and a person from California with a property over in Texas, but the execution of the agreement was in Minnesota. I mean, these are all very realistic issues that end up occurring, right? Foreign contracts, just to let you know, are okay. There are a lot of people, a lot of attorneys that say foreign language contracts, Spanish contracts, Chinese contracts are illegal. That is totally not true. It's totally not true. And so you can't use somebody's language and say, oh, well, it was in Chinese, therefore it wasn't part of the agreement. That's a very dangerous move. Personal liability, just to let everybody know that in the United States, personal liability is more difficult to get when there are companies involved, unless there's fraud or unless you merge different accounts together. Next one is arbitration. This is very important. Please start reading your arbitration provisions because it's becoming more and more popular. And the arbitration provisions that I read don't really work that well in terms of the procedure. So just be careful. And we talked about the integration clause. I put that in again, so just for you guys to remember. Got 5 minutes left. Let's see, what other tips do we have? Good E&O insurance, I think, is very important. I think that you should go to your insurance broker and ask them if there's any other insurance that you can buy on your own. I know that seems very stupid, but believe it or not, it's very beneficial. So I'll give you an example. Did you know that if you have homeowners insurance, if you get sued for defamation, they'll cover you? Did you guys know that? Isn't that cool? It's in there. It's so weird, right? Yeah, I know. People are like, what? Yeah. Homeowner insurance policies have defense for defamation. It is the weirdest clause I have ever seen. Some people are nodding, right? Most people are like, what is he talking about? Go look at your policy. So why not just carry homeowners insurance, right? So you talk to, you basically, but the exclusion is that if it's based on a business, then they will exclude you, but you can actually pay more to get that removed. Okay, anyway, just look into your insurance coverage. Don't depend on your broker, right? See what's available for you. I've said this before. Wow. Okay, we got to go through a lot. To work with an attorney, this is what you need to do. 3 pages that you need to give to the attorney. First page, what happened? On one piece of paper, one-sided. Not font 6, regular font. Okay? Second page, what do you want? Third page, what will the other side say to what you want? Basically, all the negative evidence. Give it to the attorney in advance because attorneys are always looking for cases. And typically, clients always go to the attorney that's the loudest, most abusive, most obnoxious, right? And that is not always good. You want an attorney to be ready and prepared. And so that's one way to prepare the attorney for the meeting is by writing to them what happened, what you want, and what the other side's going to do. Second, photocopy all of your documents and give the photocopies to the attorney when you retain them. Keep the originals. Why? Because 98% of scans and everything go through, but there's always 2% that for whatever reason people cannot find. And if you give the original, the attorney is going to be too scared to tell you they cannot find that document. So I'm telling you, photocopy all of your documents, give it to the attorney a copy, and tell the attorney you retain the original unless they want the original. The next one is an Excel spreadsheet. Next slide. The Excel spreadsheet, what you're going to do is you're going to take the time, I know it takes forever, to number your documents, name your documents, tell the attorney what it shows, and tell the attorney why it's important. Want me to tell you why you do this? Attorneys, believe it or not, have more than one case. They also may be married, going through a divorce, and have kids that are screaming at them, right? And so attorneys frequently are just playing, they're juggling as much as they can. Clients come to you and they say, hey, did you see what I sent you? They don't tell you if it's an email. They don't tell you if it's a text, right? They say, hey, what's the status of my case? Because they only have one case, right? Just like you, when you are buying and selling a home, the clients come to you. How many offers did I get? You're like, I don't even recognize the number. What's going on, right? And so I share that with you because attorneys sometimes when they're talking to their client, they're just like fuyan, you know, just like playing Tai Chi with them. And that's not going to help you. So you're going to take all of your documents, you're going to put it on an Excel spreadsheet. You're going to do all of this so that when you speak to the attorney, you're not talking to the attorney like just saying stuff into the air. You're going to say, attorney, can you take a look at 2-4? What does 2-4 mean? It means that there are 4 pages in the second exhibit. There are 4 pages in the second exhibit. So you just go to 2-4. And then the attorney is going to say, oh, the email between the parties. It shows that he admitted that he did wrong. Yes, 2-4. Of course. Do you understand? You're helping the attorney because attorneys didn't learn to do secretarial work. They always are thinking about legal issues. So they're notoriously disorganized, right? 9:45. Okay. Let's see what other future slides.
You have enough time.
Okay. This is very quickly 2024 trespass letters, SB 602. What does that mean? It means that before you couldn't eject unhoused or homeless or trespassers very easily, but the law has changed. So call up your police department, just say, hey, what's an SB 602 letter? And basically it allows you to lodge a letter basically saying that this property is empty and anybody that's there, you're automatically allowed to eject them. Because the problem is that some of the people that broke in ended up being tenants. I know it sounds so stupid, but that's kind of the weird circle of life that occurred. Okay, so 602 letter. Call the police department 602 letter. It's SB 602 that was the law, but everybody knows it as the 602 letter. Okay, so it allows, because a lot of people don't live in the US, it's a totally different story that I don't like to talk about, but it's basically empty homes, things of that nature, right? Okay, next slide. Security deposits, people have been asking about it. It typically caps at 1 month, but it can go up to 2 months depending on how many units you own. The law takes effect July 1st. Okay, so just look it up. Next slide. That was AB 12. Okay. Next slide is just cause evictions. So you just need to learn the wording, right? All the evictions fall under just cause, right? So there are 13 reasons for just cause, and there's something called no fault. So if you have an eviction based upon just cause, that means that you rightfully are able to evict somebody. Otherwise, it's no fault. And when it's no fault, typically you have to pay some money to get them to go away, right? So in your mind, just split, right? An attorney is going to be thinking on how to evict somebody, and they're going to be thinking, do you fall under the 13 reasons of just cause? If you don't, it's just called no fault. And the no fault basically is a no fault issue of the tenant. So the typical ways on the no fault that I think are very good, the owner occupy, I just want to warn you, it requires a 90-day move-in and a 3-year, you have to stay for 3 years. So just be really careful, because if you say you're really going to do that and you don't, I think you're going to get sued, because there are really good attorneys out there that do take on these cases. All right. I don't want you to think that these are like scammers, right? It's a violation of the law. Substantial renovation, you have to be very careful on the no fault, is that you must state what it is and you must provide documents. So there was actually a case, one of the attorneys that I had at the firm, and he went to trial on it. And it seemed to be like so straightforward, right? And it was like very easy because the tenant had already left and we're just doing damages. And the judge was like, so where are your documents? Right. And the property owner was like, well, what happened? And I had contractors, and the judge was like, yeah, but where are your documents? Right. And then the owner was kind of like, I don't know. The judge was very furious because it falls under the just cause issue. The no fault issue is that where are your documents to show that there is substantial renovations. Health and safety, obviously, and governmental requirements is another. Those are the four that I think are usually the easier ones to get by. Next slide. There's actually the guy in the blue suit with the light blue tie. He actually looks like a guy that the attorney I see on TikTok. Do people tell you that? No. So I keep on staring at him. I'm like, he's like, I think he's like a criminal defense attorney. I always see him. So, okay. Is he? So, SB 478 is advertising law. So I just put that out there so you can take a look at it. The advertising law has got a little more strict now. And so it does have an attorney fees provision. And, so there are a lot of laws that have attorney fee provisions so that good attorneys can pick up those cases and sue you, right? Employment laws are one, advertising laws are another. So Proposition 65, like if there's materials and things, chemicals in your product, you can have a really good law firm sue you because they get attorney fees. All right, so next slide.
I think we have time for maybe one or two questions at this point. Is that good?
Oh, basically just there are a lot of laws that are out there. They basically allow for attorney fees so that defendants can get sued to improve society. So one of them is the advertising laws, right? Did that make sense? Okay. Next slide. Okay. We're like super close, right? Okay. All right, guys. Very quick. Keep on going. General plan. Read your general plan. Read AB 821. Basically, we're exploring this in every city because it basically says that the general plan controls anything in contradiction to the general plan under AB 821 can be overturned. It's very interesting law. You have to look at it. This goes to mass development. So all of you are kind of looking at what's the new wave. This is the next wave. That is a statue outside of the state capitol. That statue, none of the elected officials that I've spoken to know what that statue is. Well, I'll tell you. They are the Sisters of Mercy. The Sisters of Mercy sold the Capitol property to California. Why do I share that with you? I share that with you because this statue is the Sisters of Mercy. But if you look at the very right side, you will see a nun holding what looks to be a little boy. It's actually not a little boy or girl as much as it is a Chinese orphan. So I share that with you because in 2024, race seems to be a big issue. But I just want you to know from the founding and the beginning of California, everybody has always loved each other. So I want to share that because this symbolizes so much to me of what California is and can become even better. Last thing I want to say to you. Thank you for supporting me in Arcadia, but I want to say this. I am the least adequate of all people. All of you have lived better lives than I have, more successful lives than I have, and I'm so proud of that. Why do I share that with you? I share that with you because in your brokenness and who you are, people asked about my mom this morning. My dad has passed. My dad has passed over 20 years. When I dream about him, he's so disappointed in me because I wasn't a very good son. Why do I share this with you? I share this with you because in your brokenness and your life, you think you're inadequate. I want to tell you, this time you have a choice. The choice is to believe in yourself once again. The second thing I want you to know is that for those of you struggling with family relationships, there will be a time that everything comes back together. All right, just trust me on that. Sometimes, sadly, it's after you leave, like how I think about my dad all the time. Sometimes it's in other ways. God has a plan. The third thing I want to tell you is that in your brokenness, you need to run for office. The more you are broken, the more you are broken, the more you are broken, the more you should run for office. If someone comes up to you and you have 100 reasons why you don't deserve it, I have 101 reasons why I don't deserve to be an elected official as well. Brokenness, I think, is what is needed among elected officials. Because if you are broken, you will be more sensitive to many things that other people are not. Somebody came to me in city council, not me, they came to the city council and they said, "Oh, I'm so sorry, I have an accent." And she was going like this for a long time. And I said, "I don't hear an accent. I hear a hero. You are the best of Americans. For you to come from a different country over, your accent is a sign of being a hero." Now, why do I share that with you? I share that with you because I'm not good. I'm not good. But I came from, in some ways, somewhat of a broken coming to America in 1977, where I felt really broken because everybody wanted me to go back to Vietnam, right? I wanted me to go back to Vietnam. I'm not from Vietnam, but they would say, go back to Vietnam and say a bunch of names. Is that I always didn't want anybody to feel painful about who they were and their immigrant status. And so I share that with you because it is your time. It is your time. And life is very, very short. But as an elected official, you're given opportunities, little windows of opportunities, just like in the real estate field, little windows of opportunities to make big differences in the world. And I hope that in your brokenness, if you decide to run, contact me, right? You don't have to be, everybody knows I'm super conservative. I'm very, very conservative, but I share with anybody that's willing to on how the steps to run for office. So thank you very much. Really appreciate it.
Thank you. Thank you, Paul. On behalf of the West San Gabriel Valley Realtors, please help me thank Paul Cheng again. Council Member Paul Cheng. Hey, please join us next week at the association here for the Realtors Foundation. We are hosting an annual charity auction. Bring your money, your credit cards, and come buy some good stuff for Christmas. Hey, your Christmas shopping next week. So thank you everyone for joining our meeting today. Have a wonderful day. This meeting is now adjourned.